Hello everybody, welcome to this anaphylaxis campaign webinar, which is, as some of you will know, one of a series. Today's webinar is on allergen information considerations for food sold loose and pre-packed for direct sale. This is very much a hot topic. We get lots and lots of calls to our helpline around this issue. So I'm absolutely delighted to welcome Dr. Helen Arrowsmith, who's going to lead the presentation today. Helen is a very good friend of the anaphylaxis campaign. She's a member of our corporate food panel, and she also gives us lots of advice when we're dealing with these sorts of issues. So a big thank you to Helen for supporting us in that way, and also for doing the webinar today. Just a little bit to share about Helen. She's currently Principal Food Law Advisor in the Regulatory Affairs Department at Campden BRI. Helen has worked at Campden for the past 16 years and is quite an expert in this area. And she also focused for 9 years on allergen issues, so she has particular knowledge in that area, which is great. So without further ado, I will hand you over to Helen.
Thank you, Lynn. Thank you very much. I'd just like to echo my welcome as well to this webinar. I'm going to share my screen now, which hopefully will work, and you can see my first slide. So thank you very much, and as I say, welcome. We're going to have a look at some of the allergen information considerations for foods sold loose and pre-packed for direct sale. You can't really talk about one without talking about the other, so we're going to cover both of those aspects. Just by way of an introduction to Campden BRI then. We are a non-profit organisation. We've been around for 101 years. It was our 100th birthday last year. And we provide a wide range of services, so ranging from research and innovation, analysis and testing, operational support, knowledge management. And really we're here to help the food and drink industry to succeed through the use of science, technology and information services. We are a membership-based organisation. We have over 2,500 members in 80 countries throughout the world. And we do work for non-members as well, so you'll get contact details at the end if you'd like to get in touch with us. So I'm within the Regulatory Affairs Department, as Lynn mentioned, and here we provide an advisory service to the food and drink and associated industries. We conduct label reviews, formulation checks rather. We publish regulatory updates and run training courses and seminars. So do get in touch with us if you need our help. So let's move on to what I'm talking about today. I'm going to be looking at the legal requirements for provision of allergen information for both loose and pre-packed for direct sale foods. And that acronym there, PPDS, is pre-packed for direct sale. So I'll be using that rather than saying it fully throughout the talk. I'm also going to touch on some other considerations. So hopefully you're aware that there's new legislation coming in around pre-packed for direct sale foods. And the implications there are around the provision of naming the food, the ingredient list for the food with the allergens emphasised, but there might also be some practical implications that you need to consider. One little thing to note, I'm not going to cover precautionary allergen information, so it may contain statements in this presentation. Note for Lynn there, that's possibly another webinar that we could cover in future. So not going to cover that. So what are our legal references here? We're very keen when we talk about legislation to tell people not to Google legislation because you could end up with the wrong version of legislation, and it's a good idea to know what you're looking for. So here our legal references, the primary one at the moment is the FIC, which is the Food Information to Consumers Regulation. It's the EU, harmonised EU legislation, and it's a regulation. So that means it's directly applicable in all EU member states. We all have to follow what's in there. And I say we because obviously at the moment we are still following that legislation. At the end of the year, though, we will begin to follow the retained version of this legislation. So the EU legislation will be brought into the UK. So we'll still be following the FIC. The FIR then is the Food Information Regulations. Now this is national legislation. There's actually a version for England, Scotland, Northern Ireland and Wales, so separate but parallel versions of this legislation. And what this does is it brings into our national legislation some of the aspects of the FIC, where perhaps the FIC is saying member states can decide how they do this themselves. So that's one of the functions of the FIR. We'll come on to exactly what they say about food allergens as we go through. The other place to look for information on allergen, provision of allergen information is the Food Standards Agency guidance. And for those of you not aware, this was actually updated and reissued in June of this year. So it's actually published on the 18th of June 2020. And really, it's been updated mainly to reflect the changes due to the PPDS legislation that's coming in. There's been a couple of technical and drafting updates as well. But just to make you aware, that is new legislation. Don't be looking at the 2015 version. This one supersedes that. Now, I haven't said I'm talking about pre-packed food, but to talk about food sold loose and pre-packed for direct sale, we have to understand the definition of a pre-packed food. And we find that within the FIC, so within the EU level legislation in Article 2.2e. And this is what it says. So when we're talking about pre-packed, we're talking about a single item for presentation as such, which consists of the food and the packaging into which it's put before it's offered for sale. Now, this is an important point, and we're going to revisit this later, but I'm going to give you lots of examples throughout so that we can fully understand to what products the different legislation applies. So this point here is whether such packaging encloses the food completely or only partially. So we'll come back to that. But in any event, in such a way that the contents can be altered without opening or changing the package. So again, we'll give you some examples of that. Another little note that there is at the bottom of this definition, which that is the actual definition from the legislation, it says that pre-packed food does not cover foods packed on the sales premises at the consumer's request or pre-packed for direct sale. There's no actual definition within the legislation for food sold loose, just that it doesn't follow what's written there in terms of pre-packed. So let's have a look. Let's work through some examples and help to understand this. So in terms of that definition that we've just looked at, pre-packed, here we're talking about most products on supermarket shelves. They've been packed somewhere else, probably by somebody else, other than the supermarket. So they get to that supermarket in their packed form. So an example, I'm going to talk a lot about sandwiches because the pre-packed for direct sale legislation does affect the sale of sandwiches, and sandwiches is a good example for us to work through. So using our sandwich as an example, a sandwich which has not been packed on the premises from which it's being sold. So if you go to the chiller cabinet in a supermarket, the sandwiches there will have been, on the whole, brought in from somewhere else and packed somewhere else. So that would be a pre-packed sandwich. So when we think about non-pre-packed, remember it's the opposite of that definition of pre-packed. So examples here are food from a delicatessen counter. It's there for you to choose. You might go up and ask for 200 grams of olives from the bowl of olives that's there. Those olives aren't already packed up. They're in a bowl and they scoop them and weigh them, put them into a container. It also covers, in terms of non-pre-packed or loose foods, foods packed at the consumer's request. So think fish and chips. You go into the fish and chip shop, you choose your fish and chips, and you get given them wrapped in paper. Those have been packed because you've asked for them. Okay. Another example here would be restaurant meals. So in the restaurant, you're presented your food on a plate. You don't have to unwrap it generally. So that and sandwiches served on a plate like the picture we've got there would be non-pre-packed or food sold loose. I'm going to take you through the definition of pre-packed for direct sale a little bit later on. This is just sort of a sneaky peek, if you like, as to what pre-packed for direct sale actually is. So the examples here that we're talking about are things in the supermarket which may have been packed in store. So things like you see the counter of pizzas, where the pizzas are on a cardboard base, they've had the cellophane put over them, they've been wrapped in the store. A rotisserie chicken, so often where they've got the ovens, they're cooking the chicken in the ovens, and then they're putting the chicken into bags. Those bags then would be pre-packed for direct sale, those bags of chicken. Going back to our sandwich example, where you've got a sandwich which is packed by the food business and sold from the same premises, that again is pre-packed for direct sale. We're going to come back and really go through the definition of that a little bit later on. So that's just to try and get us thinking, and also thinking about the difference between pre-packed and loose. So we're going to start with allergen information requirements for food sold loose. So remember here, we're thinking restaurants, food being served on plates. We've got a picture there which is possibly a delicatessen, possibly a buffet type scenario, food sold loose. The other picture at the bottom of the screen there, those rolls, they're not wrapped in anything, there's no packaging there. So again, those would be considered to be sold loose. So I want to take you through how the legislation is structured, because this will help to understand, in terms of the new legislation, the new requirements for pre-pack for direct sale. So we have the EU legislation, and I mentioned already that underneath that and related to it, we have national legislation. The EU legislation that's relevant to this scenario we're talking about is the Food Information to Consumers Regulation, or the FIC, and that's 1169/2011 is its number, and that is our main framework legislation that governs food information to consumers. It's where the majority of the information about labelling general foods is covered in that legislation. Underneath that then, to sort of bring that into our national legislation, if you like, we have our food information regulations, or the FIR. And these are, as I said, national food legislation, which implements and enforces the FIC. And it also allows us to do things that the FIC says that different member states can decide what they do. So what does the FIC actually tell us about food sold loose? Here we're looking at Article 44.2. And what it says in the FIC is that allergen information must be provided for food sold loose, and that was a change to previous legislation. So when the FIC came in 2014, that was a change from previous legislation. So now we have to provide allergen information for food sold loose. But the FIC says member states can adopt national measures. So basically it's up to the different member states how this information is provided. So what have we decided to do? In the UK, the legislation, the FIR, and this is Regulation 5 of the FIR, again, currently says you can do this how you like. So you can provide allergen information any way you like, in any form, including orally. But then importantly, the legislation goes on to say that where you are providing this information orally, so you're getting people to ask for this information, then you must include a label attached to the food, or somewhere on a notice, a menu, a ticket, a label, close to where the consumer is choosing that food, a statement to say that you should ask for, that the consumers rather should ask for food information. And it actually says in the legislation where the consumer chooses the food. So we're not talking here about a post on the back of a post on the way to the toilets. We're talking about up front and central, where the consumer is making that choice, whether to purchase that food. This is an example of, it's actually a pre-pack for direct sale label, which we saw on many in-store pizzas and sandwiches in a supermarket. My question to you and anybody thinking of this type of labelling is, what does an allergic consumer do with that foodstuff? Does it contain allergens? Doesn't it contain allergens? If it does, which are they? That type of labelling under the FIC is absolutely not permitted. What is permitted, though, is obviously these labels that we're talking about. So these labels or notices, where if you're providing the information orally, that's the wording. So the wording actually there on the slide is from the FSA guidance. So it tells you the type of thing that you can put on those notices. So that is what needs to be done. The FSA technical guidance also states that allergen information which is provided orally must be accurate, it must be correct. That's really, really important. And it must also be verifiable. So from that, we'd take that it should be written down. It needs to be something that somebody can check, okay? So with reference to written information, so charts, recipe books, ingredient information sheets, that type of thing. And also within the FSA guidance, it talks about best practice. So the fact that members of staff must have allergen training. They must know where to find the allergen information and how to communicate it to customers. So let's just have a quick look at allergen information for food sold loose by distance selling. And by distance selling, we're talking about takeaways, that type of scenario, also potentially over the internet. So here, the purchaser and the supplier are not in the same physical space. They're not physically present as that transaction is happening. And here in the FIC, we're told that the information on allergens must be available both before the purchase is concluded and at the moment of delivery. Now, we know that a lot of takeaways aren't necessarily doing this, and obviously with the COVID situation, we saw a lot of restaurants and pubs, that type of establishment, turning into takeaways. So there was a lot done to try and get information out to those types of establishments that this is the way to provide allergen information. So in the FSA guidance, it gives an example of a telephone order. So if you're ringing up, you're the consumer ringing up to order your food, it could be that that person is asked whether they require allergen information before the order is taken. And then at the moment of delivery, when again allergen information is required, it could be that there are stickers or receipts or maybe even an up-to-date menu which has got the allergen information on there, could be given to the consumer. And note there it says handwritten annotations, as long as they can be read. This must be able to be read, must be legible. So the best practice from the FSA guidance then is that this allergen information is held in written form by the business and available in written form at some point between the customer placing the order and taking delivery of it. I'm going to move on then now to allergen information for food sold pre-packed for direct sale. So let's have a look and a work through what this actually means. Just before we get there, let's have a look at how this sits with the legislation. So we have, as you remember, the EU level legislation, and we have our UK legislation. EU legislation is the FIC, the UK legislation is the FIR. The new amendment, the new change to the legislation is actually an amendment to the FIR, and this is colloquially called Natasha's Law. And I'm sure we're all aware that that's because Natasha Ednan-Laperouse unfortunately had a fatal reaction to sesame within a baguette that she'd bought. It was pre-packed for direct sale, which at the present time comes under the same definition as food sold loose. So all that's required there is a label to say, ask us for allergen information. So that's why this legislation has come about, one of the main reasons. So what does this legislation say? It's specific to food which is pre-packed for direct sale, and I'm going to take you through lots of examples so we can get a full understanding of what that means. And it places a duty on food businesses to label pre-packed for direct sale foods with both the name of the food and a full list of ingredients. And within the list of ingredients, the allergens must be emphasised. And it states in the legislation that this should be on the package or on a label attached to the package. So what this is doing is it's bringing in line with bringing the pre-packed for direct sale foods in line with pre-packed foods, and it's aimed at reducing confusion. So these are the statutory instruments. I mentioned that we've got separate legislation in England, Northern Ireland, Scotland and Wales. We have the statutory instruments laid for England, Wales and Northern Ireland. So these are they. And as you can see on there, the coming into force date for all of them is the 1st of October 2021. So that's when you must comply with this legislation. Note there, we haven't got the statutory instrument for Scotland yet. They have actually recently, as at the time of giving this presentation, recently opened a consultation. So from the 2nd of October until the 4th of December, businesses have the opportunity to comment on that amendment to the Scottish FIR. Scotland, the Food Standards Scotland have also issued their own technical guidance, which is also subject to that consultation. So that's one to look out for. So what is pre-packed for direct sale? This is actually a flow diagram which was part of the consultation, the England consultation for pre-packed for direct sale, and people responding to the consultation thought it was so good it was asked to be put into the technical guidance from the FSA, and that's what's happened. So to be pre-packed for direct sale, a food must meet all three of the following criteria. So is the food presented to the consumer in packaging? If the answer to that question is no, it's non-pre-packed food. If the answer is yes, then it's packed. And remember all the time that definition of packed or pre-packed. Is it packaged before the consumer selects or orders it? If no, then it's non-pre-packed. So it might be that it's packed at the consumer's request, think the fish and chips, but it's not in that packaging before the consumer selects or orders it. If the answer to that question is yes, then it's pre-packed. It's packed before the consumer orders it. Third question, is it packed at the same place it's being sold? And we're going to come back to this because there's a couple of things we need to think about here, but just for simplicity. No, it's not packaged at the same place it's sold, but it's packed. In that case, it's pre-packed food. If the answer to that question is yes, then it's pre-packed for direct sale. So this is the decision tree that the FSA have published. They've also got actually on their website a nice little tool that you can work your way through and answer those questions for your particular product. And I'll show you the website link in a moment. So pre-packed for direct sale food is packed before it's offered for sale by the same food business to the final consumer. And we're talking here about on the same premises, so it's packed and offered for sale on the same premises. It might be packed and put up for sale on the same site. And by that, the FSA are telling us that they mean a building complex, so perhaps a shopping centre or an airport terminal, where the same food business operator has more than one unit within that complex. That would be the same site. Or we're also talking about on another premises, as long as that other premise is movable or temporary. So think here about a marquee in the grounds of a hotel. If that food is pre-packed in the kitchen of the hotel, but is put out for sale in the marquee, for example, then that would be pre-packed for direct sale. So the same business who packed it, it's from that hotel. Couple of nuances to the legislation then. So pre-packed for direct sale food does include things that consumers can select themselves, and it also includes products behind a counter. We're also told in the FSA guidance that single ingredient products that are pre-packed for direct sale, you only need to put on the name of the food there. So there is actually an exemption under Article 19 of the FIC that single ingredient foods don't need a list of ingredients, and that's carried through into the pre-packed for direct sale legislation. So here we're talking about things like perhaps a box of eggs or a bag of peanuts, which are pre-packed for direct sale. remember the definition that we've talked about. So as long as that name that's on those products clearly refers to the allergens, the egg or the peanut in those circumstances, there's no need for a list of ingredients. There is also an exemption for small packs. So packs where there is the largest area is less than 10 centimetres cubed are not required to display a list of ingredients. And again, that's another exemption in accordance with the FIC. And here we're not talking about the size of the label. That's something that we often get asked. We're talking about the size of the pack, the whole container. Okay, so it's no good putting a tiny label on it and saying, well, it's under 10 centimetres, we're not going to provide the ingredients. That's not in the spirit of what's been talked about here. For food sold through distance selling, so internet or over the phone, those are not affected by the pre-packed for direct sale regulations. So those don't require the labelling that we're talking about. And in Wales, we're told that the labels can be in Welsh as long as the information is also provided in English. So here's some more examples. Let's just try and think this through and think about what is and isn't pre-packed for direct sale. The ones with the little stars by are examples actually from the FSA guidance. So sandwiches made and placed into packaging by a food business prior to the consumer's order and sold from the same premises, like the picture there, would be considered to be pre-packed for direct sale. This sandwich, which has been artfully wrapped with a piece of paper and a bit of string, perhaps it's been placed on a plate in a boutique pub. This type of packaging wouldn't be considered to be pre-packed, we understand, because you can alter the food without opening or altering the packaging. So you can get to that food. Loaf of bread placed behind a counter, maybe, or maybe even on display in a shop, but it's been placed in a clear wrapper prior to the consumer asking for it, and it's at the bakery from where it's sold. So it was packed at the bakery from where it's sold. So a loaf of bread like that on a shelf in a baker's would be considered to be pre-packed for direct sale. If the loaf is there and you go in and ask for it to be sliced and it's put in a bag, that's not pre-packed for direct sale. That would be sold loose. This is an interesting one, and I've been polling people on our recent training courses on this one. Breadsticks sold in open-ended wrappers. So it could be interpreted that those where you can get to that product, you can get to that bread without opening or altering the packaging, would not be pre-packed for direct sale. But if you seal the end of that, then it would be pre-packed. It would be packed. So it would not be, sorry, get it the right way around. It would be pre-packed for direct sale, where you can get to the food in there, not pre-packed for direct sale. So I've put a little question mark next to that one. That's not come from the guidance. That's one that we're considering. Fast food, so burgers, for example, which are packed before a consumer orders them and put under a heat lamp ready for consumers to buy them. Where you can't get to those contents without opening the packaging, that would be considered to be pre-packed for direct sale. But if you're a bit fussy and you go in and you ask for no pickles and no tomato on your burger, and they make it for you freshly and put it into a wrapper, then that is not pre-packed for direct sale. That food stuff was not packed before you ordered it. I just want to move on then, now that hopefully we understand what pre-packed for direct sale is, to talk about these things that we now need to do. So we're needing to include a name of the food and also an ingredients list with the allergens emphasised. So the legal requirement around names, you've got the reference, the FIC reference at the bottom of that slide, talks about Article 17 and Annex 6. And there's an awful lot about names of foods. When we talk about food labelling, we run food labelling courses, we actually devote a whole morning to naming food and ingredient lists, because there's that much to cover. So as you can see, I'm not going to get through all of it now, just give you the top line information and a few bullet points. So a legal name of a food is one of the options for meeting that requirement to name the food. So to name the food, there are three options. You can either use a legal name, and these are names which are prescribed in law. So there is legislation on cocoa and chocolate. It's Cocoa and Chocolate Directive, for example, which tells you what chocolate is. So it gives you a compositional requirement. So you can only use the term chocolate for a food product which looks like chocolate if it meets those compositional requirements. The same for jam and fruit juice. So where there are legal names laid down in law and probably with compositional requirements as well, that would fulfill the requirement to name the food. Another type of name that you could use is a customary name, and customary names are generally accepted within the member state where that product is sold without the need for any further explanation. So some examples which here in the UK we understand would be Yorkshire pudding. I think the majority of people know what a Yorkshire pudding is. Battenberg cake, fish finger. Consumers know what they're getting if you call foodstuffs those things. You don't often see customary names used on their own, and I should say there is no list. There's no list anywhere that tells you what a customary name is. So most often, to fulfill the requirement to name a food, you see a descriptive name. And this descriptive name is the type of name that we're used to seeing on food products. So it is sufficiently clear to allow consumers to know the true nature of the food. They need to know what they're buying, and also to distinguish it from other products with which it might be confused. So crunchy rice, whole wheat and barley flakes. I think that one's Special K. So just to give an example as to what a descriptive name is. And I mentioned there, Special K, that would be a brand name which does not fulfill this requirement to name a food. So moving on then to ingredient lists. We're told in the FIC, and this is covered in Articles 18 to 20 and Annexes 6 and 7, we're told in the FIC that the heading for the ingredients list must include the word ingredients. We see a lot of labels here at Campden when we're doing label reviews, and we're a bit geeky here in regulatory affairs. We like to look at labels when we go out shopping as well. And most often, you do see the word ingredients heading up the list of ingredients, but every now and again you see somebody who's tried to be a bit clever with it, made with in this case, filled with yummy things. I think, you know, that type of terminology we've seen before as well. That is not compliant with the legislation. The word ingredients has to be there. That's a requirement. Also, we're told that the list of ingredients needs to be in descending order of weight as at their time of use in the preparation of the food, so basically the mixing bowl stage. There are some exemptions from that, so any ingredients which are there at less than 2% don't need to be in descending order by weight. That's not to say you don't list them. That's a common misconception, is that people think, well, if it's less than 2%, we don't list it. That's not correct. It just means if they're less than 2%, they don't have to be in descending order by weight. Volatiles and water, so volatiles is thinking about brandy in a brandy butter or sherry in a trifle. And water, there, rather than at the mixing bowl stage, you're looking at the weight of those in the finished product. Concentrated and dehydrated ingredients, if they're rehydrated, could be in the ingredients list in their rehydrated form, so in that place. And then mixes of spices, herbs, fruit, vegetables, mushrooms, oils of vegetable origin, you can state in variable proportions as long as none predominates. You can see how we spend a whole morning on this. So ingredient names, they need to be detailed. They need to be as detailed as if you were selling the food itself. And they must also include references to physical conditions or treatments, where failure to do so could be misleading to the consumer. So we're talking here about food which is powdered, freeze-dried, roasted, concentrated, for example. So if you think that if you don't tell the consumer that they've got powdered vegetables in their food, if you don't think that that's going to mislead them, it's not going to have an effect on the quality or the sensory aspects of the food, it might be all right to not say. So think about whether it's misleading to the consumer not to state those things. These other considerations I'm not going to dwell on. They're just other things to be aware of. So water as an ingredient, there are particular requirements around water. So generally where water is present at greater than 5%, you have to include that in the ingredients list. But for particular products like meat products, meat preparations, you need to state water no matter what level it's been added at in the ingredients list. You need to state whether you've used irradiated ingredients and also if you've used nano materials. there's a list of permitted generic ingredient names. So to try and keep your ingredients list a little bit shorter, we're given some flexibility in the FIC about what you can call ingredients. There are rules in the FIC about how to declare additives and flavourings, and also about how to declare compound ingredients. So that's ingredients made up of other ingredients. And there are also things around ingredients that don't need to be named. So you don't need to include, for example, processing aids in your list of ingredients. So just to finish off this section on ingredient lists then, and turn to the allergen labelling aspects. We're told in the FIC, and again, you've got the references to the article and the annex at the bottom of the slide there. We're told that the allergen labelling in the ingredients list must include clear reference to the name of the allergen as listed in Annex 2. But there's a slight little side note to that. So the Commission notice, so the European Commission notice, which was published in 2017, and FSA guidance, that recent one that was published in 2020, both state, and also I should say that the previous FSA guidance said the same thing, that for things where there is particular legislation, so for cheese, cream, butter, for example, we have dairy designations legislation, which says that these things have to be made from milk. Okay, so what they're saying is that you could emphasize cheese, cream, butter, for example, rather than putting milk there. What they do go on to say, sorry, before I move on to that, what they do go on to say, though, is that, sorry, when I say they, I mean the FSA in this case. The FSA guidance goes on to say that best practice is following the BRC guidance, which talks about a strict interpretation of the legislation, so that clear reference to the Annex 2 allergen every time. So rather than emphasising cheese, you would have cheese and then perhaps in brackets milk, and the milk would be emphasised. So the requirement is that the allergen name must be repeatedly emphasised. Now, it doesn't say in the legislation you have to embolden it. I know the majority of companies have decided to do that, but you could do it any way you like. It's got to stand out. So bold, capitals, italics, we've seen good use of colour. We've also seen not so good use of colour, so just be careful. It's got to really stand out. So here's some examples. Skimmed milk powder. Milk is the Annex 2 allergen. Skimmed and powder are not in Annex 2. It's just the milk that needs to be emphasised. Couscous. Consumers might not know that couscous is wheat. So again, the Annex 2 allergen must be mentioned. The next one there, emulsifier. Emulsifier is the functional category for the additives. This is an additive declaration. See soya lecithin there. Malt vinegar. Barley, in brackets, barley is the Annex 2 allergen. Again, whey protein. Consumers might not know where that's from, so milk is mentioned. So hopefully everybody's fully aware of the specified allergens in Annex 2 of the FIC. These are the EU allergens. If you are sending products to anywhere else in the world, make sure that you are aware of not only their labelling legislation in general, because it's that you must comply with, but also their list of allergens and how you declare the allergens. There are different allergens on lists in legislation throughout the world, so just be careful with that. So hopefully everybody's aware of that. The little stars on there denote and products thereof. So things like celery includes the leaves, the stalks, also the roots, so celeriac, for example. Cereals containing gluten. Now, this is something we get asked about an awful lot and a big area of misunderstanding. Within the FIC Annex 2 list, gluten is not there as an allergen. The allergens here are wheat, rye, barley, oats. Okay, it's not gluten that's the allergen. So that gluten should not be emphasised on products. It can be mentioned in ingredients lists voluntarily, but it shouldn't be emphasised. If you've got gluten there as an ingredient, then you would have to state its source. So you might have gluten as the name of the ingredient, and then in brackets wheat, and it would be the wheat that would be emphasised. We have there obviously our list of nuts in the EU. As I said, legislation differs around the world. America, for example, have a much longer list of nuts, and include in there pine nuts and chestnuts, for example. The only other thing to note on here is that the only allergen, or the only substance rather, in this list which has a level associated with it above which you need to denote it as an allergen is sulfur dioxide and sulfites. And there's that 10 ppm, 10 milligram per kilogram level above which you need to state that it's an allergen, so needs emphasising. Should have said on the previous slide, there's also a list in Annex 2, or included in Annex 2, are things or derivatives which are derived from those substances which don't require labelling as allergens. So, for example, wheat-based glucose syrups. So there, you could call them glucose syrup. That's absolutely fine to do. You don't need to state that it's wheat. And these have undergone assessment by the European Food Safety Authority, EFSA. Dossiers have been put into them. They've looked at these and decided that you don't need to label these things as allergens. So just to finish off then, I just want to touch on some of the practical implications of the pre-pack for direct sale requirements. As you've seen, ingredient lists and names of foods can actually be quite involved, and the understanding of them is quite involved. I said I'd mention the FSA guidance. So they've not only have they got their technical guidance, they've also published a new web page on pre-pack for direct sale, and that's where that tool is that you can use to decide whether your products, whether it applies to your products. This picture is taken from that website, so I hope they don't mind me borrowing it. So there's an example that they're giving us of a label, or a sticker in that case. So what do you need to think about? What do you need? Have you got label printers? Do you need label printers? Is that how you're going to do this? Do you need to wire those label printers into your kitchen? What type of labels are you going to use? Will those labels stick to your products? So will they stick on products in the chill cabinet? Will they fall off in the hot cabinet, or go black in the hot cabinet, for example? What's the process? So actually think about the process and how you're going to manage this. Who's going to do what? Are you going to have a fancy QR code or barcode system where you can log which ingredients are going into which recipes and everybody knows what they're doing? What checks are you going to have? What sign off? This is about providing your due diligence defence to show that you've got processes in place and this is how it works. What training are you going to do? There's going to need to be training. People are going to need to understand how to label the products and get it right. So how are you going to do that? Who are you going to train? What will you do about ingredient changes? So what if you run out of margarine, for example, and somebody reaches for the butter instead, and there's no milk otherwise in that product? Think about scenarios like that and what you'll do. What about if you buy a new ingredient from a different supplier? How do you account for that? What if things go wrong? A lot of this is going to be down to humans, and of course there could be human error. So think about incident management. Think about what would happen if things do go wrong or did go wrong. And also trend monitoring. So if you are having a look at, if you're checking rather labels before the food product goes out to the shop floor, or before the consumer buys it, are there trends? Are there particular ingredients that look like each other? So they're getting that wrong each time that product's made, or more often when that product's made. So just think about that type of thing. So things to remember, take-home messages then. We've talked quite extensively about the definition of pre-pack for direct sale. Remember, it's food presented to the consumer in packaging. We talked about the packaging. It's packaged before it's selected or ordered by that consumer, and it's packaged at the same place with all that information around what we mean by same place. So same place it's sold. If the food is pre-packed for direct sale, so if you decide that this does apply to your operation, then it needs to be labelled with the name of the food and an ingredients list with the allergens emphasised from the 1st of October 2021. That's when this legislation will begin to be enforced. And always remember, allergen information must always be current and accurate. This is a food safety issue. It's really important. That's the slide that I said about with our contact details on there. So if you have any regulatory inquiries, there's a particular email address there for getting in contact with us in the Regulatory Affairs department. If you have any other questions, we have our support email address as well. Get in touch, you know, hopefully we'll be able to find somebody to help you. So thank you very much for listening. My last slide is one from the Anaphylaxis campaign, just to tell you a bit about their resources as well. They do have guidance on relevant food legislation on their website, and the link is there. Corporate membership link is on the slide, and they also offer training, so allergy-wise training for parents, schools, health and care professionals, and of course there's the helpline as well. I hope I've done you proud with that, Lynn.
Very much so.
Good. Thank you. Shall I stop sharing?
Yes, please.
So
That'd be great.
See everybody. There we go.
Huge thank you to Helen for that presentation. I think that was incredibly informative and on a topic that is really complex, actually. So,
it is. Yeah.
So thank you, Helen, for really drawing out the clear messages. I think what shows us how important this topic is the fact that we've been flooded with questions. I think we've had more questions for this webinar than any previous webinar, which is quite understandable. We're not going to get through all the questions today, but what we will do is we will put a Q&A on our website, and then if your question hasn't been answered, we don't get to it, you can look at the answer on the website, and I'm sure other questions will come to people's minds as we're actually going through the topic, these questions now. So I'll start off with the first one, Helen, which is, we have a small takeaway business and make most food to order. However, we sometimes pre-pack batches of popular products in advance. Will those pre-packed products now need to have full ingredients labelling, even though it's exactly the same as the one we packaged to order?
I think what we need to do is think about the definition of pre-pack for direct sale. And I would say that if the consumer is coming into the shop to purchase that sandwich and take it away, then my interpretation would be that yes, those pre-packed batches, even though the sandwiches are the same as ones which are being sold loose, if they've been wrapped before the consumer chooses them or orders them, then I would say that yes, the pre-pack for direct sale legislation does apply. The food is pre-packed, it's packed before the consumer orders it, and it's packed on the same premises from which it's being sold. So yeah, I can see that would be covered. It does depend though whether the consumer is ordering those sandwiches by means of distance communication. So if the consumer rang up to order that sandwich and the sandwich is delivered to them, it's that form of takeaway. That by means of distance communication is relating to the fact that the supplier and the consumer are not simultaneously physically present, and that's from the legislation. I love that. They're not there at the same time. So in that case, that would be considered to be food sold loose. So then the allergen information would be required before that that food was ordered, and then at the moment of delivery. So it depends how the consumer's actually purchasing that food stuff.
I think the answer to that question perfectly illustrates just how complex this issue is and all the different nuances that need to be taken into account.
Absolutely.
I'll move on to the next question. I run a small grocery business and sell some sandwiches made and packed by the artisan baker next door. Do these sandwiches fall under the new PPDS rules?
Lots of sandwiches. it's a lot about sandwiches,
isn't it? Sandwiches are a key topic on this.
Absolutely. Again, my interpretation would be that yes, they do need to comply with the PPDS legislation. The sandwiches in this case are actually being packed by a different business. So in this circumstance, really, they should be considered as pre-packed, in which case they would need the full relevant mandatory particulars on that packaging. So everything from the name of the food and the ingredients to nutrition declaration, quid, quantity, durability indication, or I've probably missed out a couple there, but yeah, all the relevant mandatory particulars would need to be on that product, I would say.
The next questions is deceptively simple, but I'm
Right.
sure that the answer is not simple. And it's, do the new regulation cover drinks as well as foods?
Right, yeah, yes, because we're talking about the Food Information to Consumers Regulation and the FIR, which is the Food Information Regulations, all mentions of food. Completely see where that's come from. There is actually an EU definition of food. So the EU definition of food is in the General Food Law Regulation, which is 178/2002, and it's stated that food is any substance or product, whether it's processed, partially processed or unprocessed, which is intended to be or reasonably expected to be ingested by humans. I think we can all understand that that's what food is. But it goes on to say that food includes drink. So it includes drink, chewing gum, and any substance, including water, which is intentionally incorporated into that food. So yes, drinks do come under the definition of food. So this does apply to drinks as well.
I think that's quite an important point, actually, and I think there is some misunderstanding around that. So thank you for clarifying that, Helen.
Okay.
The next question, which is a bit more straightforward. It's nice to have ones that have a black and white answer sometimes. Are the regulations coming in October 2021 for all 4 UK nations or just England?
No, so the legislation that's been laid already in Wales and Northern Ireland also has that 1st of October 2021 date associated with it. The Scottish legislation, which hasn't been laid yet but is subject to that consultation, the understanding is that they are intending to have that also brought in, so enforced from the 1st of October 2021. So that's the intention, is that they will all be on the same date, will be enforced.
The next one touches on a topic which you deliberately said that wasn't included in the presentation, and I take your point, it merits a presentation, a webinar on its own, and I've already made a note of that. But the question is, do we need to include precautionary allergen labels on foods for pre-packed for direct sale, as well as full ingredients listing?
So I didn't want to talk about precautionary allergen labelling, or may contain statements as they're often called, because it's a particularly, I won't say difficult area, but there's no specific legal requirement to provide a may contain statement. So it doesn't state anywhere in the legislation that you have to do that. So in answer to the question, no, but, and that's a lot with law, isn't it? It's a no or a yes, but. The provision of precautionary allergen statements is there obviously as a food safety issue, and they are provided voluntarily, and they're provided voluntarily under the General Food Law Regulation 178/2002. We have guidance, we have old guidance from the FSA, and we also have the new guidance. So the old guidance used to be related specifically to precautionary labelling. It's from 2006, the guidance I'm referring to. And within there, and also within the 2020 version of the guidance, they say that these types of statements should only really be used after a meaningful risk assessment, and there is considered to be a significant and real risk of cross-contamination of those allergens into those foods. So they should absolutely not be used as a substitute for good hygiene practices or good safety practices. So I can't say absolutely yes or absolutely not, because there's no piece of legislation that says you have to do this. You can voluntarily do it, but if you do voluntarily do it, the decision must be based on that robust risk assessment as to whether there's potentially real cross-contamination into that food. Okay.
Thank you very much, Helen. The next one, where can we go for help to make sure our business gets this right? I mean, there's obviously Campden and your good self, but where else should people go?
I heard somebody quite wise the other day say that there shouldn't be any competition in food safety, and I think that's a really nice thing to say. So I'm going to say yes, you can come to Campden BRI, but there are other food consultancy businesses out there as well. Obviously, I've mentioned the Food Standards Agency in terms of the guidance that they've published, and that website page as well that they have. Of course, yeah, you can come to us. It might be that you want to seek an enforcement opinion. So, I mean, we at Campden can certainly provide advice which can help with a due diligence defence, but we don't provide legal advice. We provide an interpretation based on our experience and based on our knowledge of enforcement opinions, that type of thing. If you want an enforcement opinion, then it would be worth contacting your local or your primary authority, if you have a primary authority agreement, to get assured advice. But so there's several places you can go to hopefully help you get this right.
We've had so many questions. I'm trying to squeeze in as many as possible. I'm going to put one more in.
Okay.
And then, as I say, for all those people who've been sending us questions, we will put them on a Q&A on our website, and the presentation and this webinar will also be available to everybody. But I was quite intrigued by this one, so I'd be very keen to hear the answer. Does this legislation apply to a works canteen where sandwiches and baked goods are packaged by the canteen manager and placed into a vending machine for later purchase?
Right, I'm going to come clean and say that we had this before the webinar, which I'm very pleased about, because this one gave me a lot of cause for thought. So, generally, vending machines are considered to be distance sales, because remember that definition, the consumer and the supplier are not simultaneously physically present. But in this scenario, we're talking about a vending machine in a canteen where the people in that canteen have produced that food. So I'm thinking perhaps it might be considered that that vending machine is seen to be on the same site as the canteen. So in that case, it could be that the pre-packed for direct sale legislation does apply, so that you'd need a name and an ingredients list. If that food stuff is packaged and is in a vending machine somewhere else on a different site, then that would be considered to be pre-packed, and that item of food would need to have the full the full labelling information, not just allergens, including nutrition, that type of thing, on that package. Because the requirements for food, pre-packed food sold at distance, are that and particularly sold in vending machines, I should say, is that when that food is delivered or the consumer receives it, that's when they get the full information. So if it's within the canteen, it's considered to be on the same site, so the pre-packed for direct sale applies. Or it could be, if it's somewhere else on the site, not on the site, somewhere on a different site, then it would need to be fully labelled. It's not loose. I did think about this. A loose sandwich in a vending machine is not going to work from a practical perspective. If it was non-pre-packed, so loose food in vending machines, like soups or hot chocolate, hot drinks, coffee, that type of thing, for those, the allergen information needs to be provided to consumers before they purchase the food. But I don't think that's relevant in this circumstance. So that one, I think I would personally, if I was a client, I would like to get an enforcement opinion on that. So as I was just saying a moment ago about enforcement opinions, I can interpret the legislation and say that yes, I think it would need to comply with pre-packed for direct sale if the vending machine's in that canteen or on that site. But I would personally like to have an enforcement opinion on that one.
Thank you, Helen.
Okay.
Now we've pushed it right to the wire.
Okay.
Our hour is up. can I just say thank you so much. That was a brilliant presentation, very clear on a very complex topic. That was absolutely fantastic.
Good.
And I've been watching actually the number of people who joined us at the beginning of the webinar. Every single person has stayed to the end. So
thank you.
So I think you've actually held everybody's attention right the way through.
That's good to hear.
Thank you.
Thank you.
Thank you. As I say, the presentation will be available and also the webinar and in full because we've been recording it as well as doing it live, and there will also be a full Q&A on our website www.anaphylaxis.org.uk. So a huge thank you to Helen and a huge thank you to everyone listening, and enjoy the rest of your day. Thank you.
Thank you.